My name is Suzanne Bond, and I'm here on behalf of the Illinois State Police. We are pleased to offer 3 public hearings regarding ISP's proposed rules pursuant to the Protect Illinois Communities Act. And we thank you very much for coming and being with us today. ISP is committed to fulfilling the duties and responsibilities the legislature set forth for it in the Act. ISP has developed and implemented a public notice and published several resources on its website to help people understand and comply with the Act. For example, our website has links to the Act, ISP's proposed rules, a PICA identification guide, as well as numerous FAQs. Additionally, ISP has posted routinely on its social media channels about the requirements under the Act and produced a tutorial to help guide the public when disclosing assault weapons, assault weapon attachments, 50 caliber rifles, and 50 caliber BMG cartridges as defined by PICA. The PICA Identification Guide is intended to assist Illinois residents with determining whether they have an assault weapon regulated by the Act. To the extent they do, we remind them to use our website to submit their electronic endorsement affidavits prior to January 1st, 2024. The FAQs are intended to provide additional guidance to ensure Illinois residents can comply with PICA. We have been updating our FAQs regularly, even during the course of these hearings. As we get questions and are able to answer them, we're updating those FAQs. ISP has made every endeavor to ensure our administrative rules are within the authority set forth in the statute by the legislature. These hearings are held to gather your questions and ensure we have addressed them within the limits of our authority before we move to second notice in the Joint Committee on Administrative Rules process. The public comments we have received for the hearing today will be read, and then we will acknowledge those individuals who submitted witness slips to speak at today's hearing. As a reminder, per the public notice, if you did not submit a witness slip in advance, you will not be permitted to speak today. However, the ISP will be accepting written comments until November 20th as part of the first notice process for its proposed rules. The email address for the public comment portal is available on our website. Please remember your remarks are limited to 3 minutes. People speaking on behalf of a group, organization, or their constituents will be permitted 9 minutes. If a question is posed today and ISP has already answered the question, I will read the FAQ and answer in response to the question. Today's meeting is being streamed and recorded. I would like to add that we are having some difficulty with video, so on the streaming, the video may cut out, but the audio will continue. Now we will move to the reading of the public comments. These comments do not reflect the views or opinions of the ISP, but rather are being read verbatim into the record as a part of this public hearing process. To the extent that questions were submitted as written comments, they will be read into the record, answered to the extent possible today, and addressed further during the first notice process where necessary.
First written comment. We wish to express our support to the Illinois State Police in their work to propose rules under the Firearm Owners Identity Card Act. We appreciate the work of the Illinois General Assembly and the governor in enacting the Protect Illinois Community Act, especially in light of the recent mass shooting in Maine and last year's shooting in Highland Park. Moms Demand Action is a grassroots movement of Americans fighting for public safety measures that can protect people from gun violence. We work to pass stronger gun laws and to close the loopholes that jeopardize the safety of our families. The Metro East group of the Illinois Moms Demand Chapter encompasses East St. Louis and areas to the northeast in the metro area, including Monroe, St. Clair, and Madison counties. Thank you for your time and consideration. Next written comments are by Chief Munchensky. The barrel shroud language. Is a Ranch Model Mini 14 and 1022 legal? Readily convertible magazines. The statute bans magazines that are readily convertible to high capacity. What does this mean? Is the 1022 okay because the handguard is part of the stock? What about something like a Kel-Tec RDB-C or a handmade handguard for a Fight Light SCR receiver? We need clarification not just on what guns are fine, but why they we need clarification, not just on what guns are fine, but why they're fine and others aren't.
Answer to these questions can be found on the ISP website on the Protect Illinois Communities Act page. Specifically, I would point you to FAQ number 8. Is a forestock considered a barrel shroud and therefore regulated by PICA? No, a shroud is not an integral component of the stock, but rather a separate piece. For example, the wooden forestock on a base model Ruger 1022 does not constitute a shroud. I would also point you to the ISP's guide on its website. Other examples of forestocks not constituting shrouds would be the base model M1 carbine, M1 Garand, and Savage model 850. Assuming they have no other features regulated by PICA and/or have not been modified to include any regulated features or attachments.
What parts are we legally allowed to purchase in the event one of our weapons break or we lose a trigger spring or a pin on a grandfather gun?
Again, I would refer you to the website and to the FAQ, specifically see FAQ number 41. If an Illinois resident has an AR-15 or assault weapon prior to the passage of this act, where can they legally possess the firearm? After April 10th, 2023, an Illinois resident can legally possess the firearm on private property, owned or immediately controlled by the person, on private property that is not open to the public with the express permission of the person who owns or immediately controls such property, while on the premises of a licensed firearm dealer or gunsmith for lawful repair, at a licensed firing range or sports shooting competition venue, or while traveling to and from these locations.
What is the definition of a flash suppressor? Is a muzzle brake included in this as well? They are two items with two different functions, but there's no guarantee they know the difference. Flash suppressor to mean all muzzle devices. An example for this is an M1A legal if the flash suppressor is swapped out for a muzzle brake. Does the MA plastic barrel cover count as a barrel shroud? The law and the ISP examples conflict.
Again, I would point you to the FAQs on our website, specifically see FAQ number 9. Is a muzzle brake considered a flash suppressor and therefore regulated by PICA? The answer, while both are barrel attachments, they serve different purposes. A flash suppressor is designed to reduce the muzzle flash of the firearm. On military firearms, this is to prevent distant opponents from seeing where someone may be shooting from. A muzzle brake directs the energy of the muzzle blast in a specified direction in order to reduce the felt recoil of the discharge of the firearm or to prevent the muzzle from jumping during shooting. Most muzzle brakes do nothing to reduce the flash, and the specific one produced by Springfield has been ruled by ATF to not be a flash suppressor.
What is the policy of the state police with regard to investigation and identification of PICA categorized firearms purchased between the April 28th injunction and the ensuing stay issued on?
Again, I am going to refer you to the website and the FAQ, specifically see number 16. How will this law be enforced? Law enforcement agencies, including the ISP, are charged with enforcing the Protect Illinois Communities Act throughout the state. ISP will continue to enforce the FOID Act and Article 24 of the Criminal Code of 2012 by partnering with local law enforcement through our Violent Crimes Intelligence Task Force. The task force is a collaborative effort to reduce and prevent illegal possession and use of firearms, firearm-related homicides, and other violent crimes.
What is the policy of the state police with regard to the 99.9% of owners of PICA categorized firearms who have historically been fully compliant with firearms laws that simply don't capitulate to a registration which they are reasonably likely to be unaware of?
Again, I would point you to the same FAQ number 16 on the state police website.
Please describe how the registration above is compliant with Title 18 U.S. Code and the Firearm Owners Protection Act of 1986.
Again, I'm going to refer you to the state police website and our FAQs, specifically see FAQ number 33. How is the Firearm Owners Protection Act of 1986, 18 U.S.C. Section 926, relevant to the ISP rulemaking under PICA? The answer is it isn't. 18 U.S.C. Section 926 applies to the U.S. Attorney General of the United States and sets forth what rules and regulations a federal agency may create to regulate firearms. The authority for the PICA and the endorsement affidavit is based upon a statute passed by the Illinois legislature and is not a rule or regulation created by a federal agency. See National Shooting Sports Foundation Incorporated versus Jones, 405 U.S. Appellate Court, D.C., 18/2013.
What logic requires a citizen, after having completed a multi-month process of applying and receiving a FOID, who can now be instantly and digitally identified to have previously purchased firearms, open paren, 10-year FOID extension, close paren, to wait 3 days to receive any new firearm after purchase?
This question does not pertain to the provisions of the Protect Illinois Communities Act and will not be answered today.
Please describe how the digital record of purchase is compliant with Title 18 U.S. Code and the FOPA 1986.
Again, the answer to this question can be found at our FAQ number 33.
That concludes the written comments to be read aloud.
So next we will move to the in-person testimony. We will be starting with organizations, and our first speaker today is Mr. Ed Sullivan with the Illinois State Rifle Association.
Thank you. My name is Ed Sullivan. I represent the Illinois State Rifle Association. First off, I want to thank the Joint Committee on Administrative Rules for ordering these 3 hearings to try and get to the bottom of what we're trying to do in registration. Obviously, state police got a piece of legislation that is deeply flawed, and I understand the difficulties in trying to get these rules correctly, and that's why we're here today. So we have had several hearings, and I don't want to duplicate some of the things that have taken place, but there's 2 issues that I want to bring up that I think are relevant, and hopefully we can get some clarification on. The first one is with private security personnel that have a firearms control card. What we know is security people under this act, and I am going to read directly from it, exemptions for official duties. The following persons are not required to complete an electronic endorsement affidavit to possess an assault weapon while the person is performing their official duties. It goes on to say in B, however, these persons must complete an electronic endorsement affidavit if their possession of these items extends beyond the performance of the official duties. So I want to kind of narrow down what that means. Specifically, as we said, a security personnel armed with an FCC, firearms control card, they own their firearms. It's no different than a plumber or a mechanic, that their firearm is their tool in what they do. So the question I have is, if they're off duty, but still in possession of the firearms, are they in violation? So their employer does not present them with the firearm. It's theirs. And so that's the first question. Second question, are they in violation if they use these firearms to train? So obviously, if you are an employee that your livelihood depends on you being able to operate a firearm properly and under the right circumstances, you should be training weekly. And so if they haven't filed an affidavit, are they in violation? So those are the 2 questions as it relates to private security personnel.
Answer those questions?
Sure.
As our rules are drafted today, yes, they would be in violation. If they own the firearm and they have not filed an endorsement affidavit, they would be in violation as of January 1st, 2024. However, we understand that this is a concern that has been raised regarding that interpretation, and we will be working with JCAR to further clarify the rule to the extent it is within our statutory authority to do so. At this point, we do not have proposed language that would address that concern.
So if we propose language and to try and help you along, would that be possible?
Absolutely.
Great.
The public is welcome to submit suggestions with respect to our rules during the public comment process. There is a public comment portal, and you are free to submit questions, proposed language, anything like that that you think would help with this process.
Okay, well, I appreciate that. So the biggest issue that I see, I mean, there's lots of issues, but the biggest issue I see with this, these proposed rules is section 1230.50, return of FOID card applicant. Section B, assault weapons attachments, 50 caliber rifles, 50 caliber cartridges, and large capacity ammunition feedings devices transferred to another person as a result of a suspension may not be returned upon reinstatement of the FOID card. So obviously you're trying to gear this towards law enforcement. So I have two cases that would be real life. Under the Firearms Restraining Order Act, an ex parte order for someone having suicidal thoughts. Family member says, man, that he might kill himself, or, you know, whatever. Maybe it's a cousin or someone that's able to file a firearms restraining order. Under the act, they are, under 8.2, they are going to lose their FOID card. Under that, they are going to have to, under the FOID Act 9.5, are going to have to turn over their firearms to somebody. Under your rules, it says you have to comply with 9.5. So that person turns their firearms over to, you know, an individual that's a private entity, not a governmental entity. Their firearms are gone. They're out of their possession. 14 days later, under an ex parte order, there must be a hearing. At that hearing, the judge says, no, you're fine. And they remove the order. They are supposed to get their firearm privileges back. Under your rules, because that person had turned the firearms over to a private entity, you're now saying that they cannot get those back, even though it was a false claim at a government hearing. How do you justify that?
The statute does not permit possession by another person during that time period. So the Illinois State Police has endeavored to give people an option, which is to surrender it to law enforcement until that process can play out, at which point their firearms would be returned to them. The state police does not have the authority to enact rules that exceed the language of the statute. We understand this is a concern, and we will be working with JCAR to address it.
Okay, so I have another case based off of what you just said, that they have to go to that they have to go to law enforcement, or you're suggesting they go to law enforcement if you want them back. Well, what happens if you can't get them back? And let me talk about another example. So once again, Firearms Restraining Order Act or any type of other order under the law today, let's say the person turns their firearms over to law enforcement. Why don't we stay within the Firearms Restraining Order Act? At the hearing, they find out that this person is his habitual drug user or maybe has some severe mental health issues. They lose their FOID card permanently. Under present law, Firearms Restraining Order Act, when you turn over your firearms to law enforcement and they cannot be turned back over to that individual because they've lost their privileges, because they've lost their firearms owner identification card. I'm going to read you from the Firearms Restraining Order Act H. Cannot be returned to the respondent because the respondent cannot be located, fails to respond to requests to retrieve firearm, or is not lawfully eligible to possess firearm, ammunition, or firearm parts that could be assembled to make an operable firearm under petition from law enforcement agency. So once again, they lose their FOID card. Now the law enforcement agency can petition the courts to do a few things. Here's what they can do. The court may order the law enforcement agency to destroy the firearms, use the firearms ammunition for training purposes, or use the firearms or any other application deemed necessary by, I was paraphrasing there, of course, local law enforcement. So in there is nowhere where you can give them back to somebody. And so what do you do with someone that has, I don't know, $100,000 worth of guns? And they turn them over to law enforcement because they have a problem. Are you going to not be able to turn those back over to the people? Because under law, under present law, there is no way for them to be turned back over to the family. $100,000 could be, you know, a couple kids going to school, but you're going to take them under this act. And so where your rules and present law don't really follow, I think we really have to have those discussions. Now, listen, I don't know why anybody would comply with this act. I have no idea. Why would you ever register a firearm with government? But there will be people that will, and that's fine. I respect that. But these rules have to be clear enough so people don't become criminals by no fault of their own. So I thank you for your time.
Take a note of the final example that you gave us, and we will endeavor to address that issue. We understand the concern and we appreciate your today.
Thank you.
Thank you. Okay, we will do better to project. If you are having a hard time hearing, if you will raise your hand, that will alert me to the fact that you're still having a hard time hearing. Okay. The next speaker is Ms. Valinda Rowe with IllinoisCarry.com.
I'll try that.
That's fine, thank you. We're gonna have her face you and allow you to hear her better.
Good morning, Belinda Rowe. I'm the spokesperson for IllinoisCarry.com. And then this won't pick me up. I have to be picked up here. Sorry. Thank you for the opportunity to speak today. I have been working with the Illinois State Police since concealed carry passed, and I would just like to say that I greatly appreciate the working relationship that we have been able to build over the years, and I hope we can continue to do that to help clarify a lot of things that need to be clarified. From questions asked today and in the prior two hearings, it should be very evident that from those who have spoken that the information on the ISP website is not clear enough. And that even though you have answers on the frequently asked questions, I would strongly urge you to review those and make sure they're in plain English, common use language that we can all understand. It's very important when we're facing felony charges that we know in black and white without question what the situation is. And we need correct information in regards to incomplete lists, incomplete answers, incomplete flowcharts, incomplete photos. We're all still up in the air about what is legal and what is not. And just encourage you to update those. In regards to the new updates and changes that you do make, we would ask that there be an indication or an index of those changes and the date that they were made, so that we know that when we go to review the page that we are up to date with the information there. Currently, we just have to comb through the questions and answers and see if any of the language has been changed. And with a huge volume of information, that's very difficult to know if we have the most current information.
We will make a note of that.
Thank you. Okay, so my questions as spokesperson for Illinois Carry come from questions that members have brought to me to ask. The first question is concerning our current and retired law enforcement officers specifically, but also others on the list who may be exempt from the ban on purchasing and possessing prohibited firearms, magazines, and parts. The question I'm getting from members is, are these same individuals exempt from the requirement to register? Although they can purchase and possess, the register part comes into question. And the question arises because although corrections officers are exempt from the purchase and possession prohibition, frequently asked question number 22 says that they must register their personally owned firearms because they might not always qualify for the exemption. Wouldn't that be the same for others who are exempted by virtue of their employment? Even active law enforcement today might not always be active law enforcement, and they may not retire. They may leave service in between there. The window will have passed to register. What will happen to those individuals?
I believe the FAQ you're referring to encourages them to do so while they are still employed. However, the Illinois State Police is not going to shut its endorsement affidavit portal down. Nobody will be prohibited from submitting an endorsement affidavit even after the January 1st deadline passes.
But my question then would go to if they, being while they are exempt, they purchase firearms after the deadline. Will that affidavit be saying that they owned these items prior to the deadline for registering?
No, they will be able to put in the date that they purchased it.
Okay, all right. Second question. On the state police webpage under frequently asked question 45, there is a question about magazines and with removable base plates that can be converted to hold more than 15 rounds for pistols. The answer, a large capacity ammunition feeding device, means a magazine, belt, drum, feed strip, or similar device that has a capacity of, or that can be readily restored or converted to accept more than 10 rounds of ammunition for long guns, more than 15 rounds of ammunition for handguns. And the answer, a 15-round magazine without an extension kit is legal. However, ISP's own answer cites the language of can be readily restored or converted. Despite ISP recognizing that language, it ignores this in its answer. How does ISP justify ignoring the plain language of the law when these magazines are in fact readily convertible by simply removing the base plate and adding an extension?
And the Illinois State Police is aware that the public has asked us to help define readily converted, readily modified, and we will be working with JCAR in the coming weeks in an effort to do so. Thank you.
It's somewhat in tongue-in-cheek, but also seriously. Todd Vandermeide last Friday talked about his Star Wars lightsaber and whether the parts used on it would have to be registered. And that kind of raised a question among our members then about airsoft that uses some of those same parts. FOID cards are not required to possess airsoft items. Children own a lot of these. People who do not have FOID cards own these. And so the question is, how will this work for those individuals? They don't have a FOID card to register under.
Okay, so I'm going to answer your question in two parts. You do not have to have a FOID card to register any item, but specifically an assault weapon attachment. Additionally, the Illinois State Police is aware of this concern regarding parts designed for airsoft and whether they are subject to the endorsement affidavit provisions, and we will be working to get guidance out to the public on that. We're in the midst of these hearings, so we simply haven't had an opportunity to address that issue and get an answer to the public, but we will be doing so in the coming weeks.
My next is not necessarily a question, it's more of a statement. Our officers have gone through considerable hardship and hard work to get jobs which enable them to help and protect the good citizens of Illinois. They're on the flip side of this coin. The oath of office for sworn ISP personnel requires giving thoughtful, intelligent obedience to orders juxtaposed against upholding the four intersecting pillars of the U.S. and Illinois Constitution and U.S. and Illinois law. In light of the recent New York brewing decision by the U.S. Supreme Court, which clearly opposes this law and these rules being discussed today, our officers did not sign on to enforce such an obviously unconstitutional law. Most of our officers will be forced to violate all they know to be true about the Constitution and Second Amendment or risk losing their jobs. They are being trapped into enforcing a law on a citizenry who is also trapped by the confines of living in this state. It is a sad day, and they have tough decisions to make. And although we are here today in an attempt to clarify and define the rules, we all know that citizens of Illinois are going to wholesale ignore all of this. Many local law enforcement agencies will not enforce it. Huge numbers of state's attorneys have already said they will not prosecute it. These hearings really are just a pretense that this law will survive constitutional scrutiny, and what's worse, further pretense that this will bring any change in regards to protecting our communities and making them safer as a result of this law and these rules. Instead, we all know we should be looking at mental health issues and violent criminal issues, if not more so. Those issues are more prevalent than the weapons that are used in these atrocities. Time and time again, the signs of mental illness are there, especially in like the 4th of July killing that's being mentioned quite often during these hearings. I encourage you and Director Brendan Kelly to urge current administration to find ways to protect its citizens from those who are mentally dangerous and put our efforts there instead of creating ineffective laws and rules that put our law enforcement at risk of violating the constitutional rights of law-abiding citizens and do nothing to make us safer. So
We also appreciate the careful thought that you put into your comments and the questions you submit to us. If you have additional, please submit it in this. We would appreciate it. Thank you. Next up, we invite Mr. Dan Eldridge to speak on behalf of FFLs of Illinois.
Thank you, and thank you for having this hearing. My name is Dan Eldridge. I'm president of the Federal Firearms Licensees of Illinois. Speaking on behalf of our more than 100 member FFLs and other supporters, I won't waste any of my 9 minutes or your time rehashing the excellent points made in the past 2 sessions and today. Instead, you've referred repeatedly to your FAQs and the illustrated guide for identification, and those do raise some issues that I'd like to address here. First, the FAQs, are they static? Will they be changed or added to?
They will be added to.
Without any sort of change log, how can people rely on those to make consequential decisions?
We have heard the request for a change log, and we will work to see how we can address that.
FAQ number 6, can I repair my assault weapon if it becomes damaged? You repeatedly refer to FAQ 41, but there are issues outside of FAQ 41 that arise from this. For example, at the end of that FAQ 6, since individuals are not provided an exemption to purchase so-called assault weapon attachments, such parts need to be replaced by an FFL or gunsmith. Okay, but I cannot buy to sell to an Illinois customer a vertical ring grip. I cannot buy any of these banned items in order to install on a weapon. So if the item itself is damaged, the firearm is useless. Repairs that require more than while you wait service. An FFL must log that firearm onto their books if it's going to be kept overnight. Once it's on my books, I cannot return it to the customer. So now any overnight repairs cannot be accomplished on the firearm, rendering it inoperable. Repairs that go back to the manufacturer require us to log it in, send it to the manufacturer, they log it in, we get it back. Again, we cannot transfer these firearms back to customers that own them, perhaps lawfully and registered and all of that. We can't transfer them back. These firearms are not repairable. I would suggest that you correct FAQ 6 to make this point very clear to people before they get caught up in a trick bag here. FAQ number nine, small comment, but I think it's significant. You misspelled break. This is a document that people are supposed to rely on for guidance in very, very consequential decisions. It really should be correct. FAQ number 25, assault weapons owned by individuals, even if the person owns a business or is licensed as an FFL, are subject to the endorsement affidavit. Could you elaborate on that? Does that include shop inventory, rental guns, owned by the corporation that holds the FFL, or owned by a sole proprietorship? What do you mean by that? There's a great deal of confusion among our members on that.
Okay, we will endeavor to make that clear. Thank you.
26, the FFLs need to complete the endorsement affidavit. Individuals under FFLs not exempt pursuant to 1.9E must comply with the endorsement affidavit requirements. Businesses that are FFLs may complete the endorsement affidavit for any regulated items still within their inventory. Again, it's an issue. It's more inventory for guns is the FFL held by a corporation, how is it held? Obviously, an individual like me would be subject to that for my own personal property, but the way this is reading, a number of FFLs have come to us and said, I don't know how to do this. My business doesn't have a FOID card. FAQ 28, how can the Illinois residents sell or transfer banned items? After January 1, 2024, they may transfer the so-called assault weapons to an individual residing in another state, maintaining it in another state, or to a federal firearms dealer. The correct term is licensee. Again, the language matters and precision matters here. However, in FAQ 37, as an FFL, can I maintain inventory of regulated items for sale? Yes, an FFL can maintain their inventory as of January 10, 2023, and I'm skipping forward here. An FFL cannot purchase additional assault weapons to maintain an inventory. However, an FFL can obtain additional assault weapons on behalf of persons exempt from the purchase provisions of PICA. Please refer to blah, blah, blah. Okay, this is very, very misleading because within PICA, if you do go to 24 1.9 and 1.10 and read through, interstate commerce is not impacted here. There is no prohibition for an FFL, be it a distributor, a manufacturer, or a retailer, to purchase banned items for resale out of state. Yet this is suggesting that it is.
We will take your concern under advisement and work to correct that.
So, while we're on this section, 24.1.9D4, a person authorized in this section to possess such items only at, quote, a properly licensed firing range or sport shooting competition. Many of our members own ranges open to the public, but to the best of my knowledge, there is no such thing as in Illinois as a licensed firing range. This is clearly a cut and paste from somebody else's assault weapon ban. Please clarify, will the department view it as a violation for customers to lawfully use their legally possessed firearms at our non-licensed range?
Or I'm going to have to do some research on that.
PICA guide. C, Roman numeral 6, a buffer tube, arm brace, or other part that protrudes horizontally behind the pistol grip and is designed or redesigned to allow or facilitate a firearm to fire from the shoulder, to be fired from the shoulder, sorry. A buffer tube is designed to allow the bolt to operate. That's all it does. And I just can't understand how that would fall into this guide. You cannot mount a buffer tube on your shoulder. That would be painful. Yes, there are modifications, but the design of the bolt, the design of the buffer tube is to contain the recoil spring and the bolt, nothing more. Also in the Act 24.1b, that's in the UUW penalty section, each weapon or attachment is a violation. So one rifle with 2 features or attachments is how many offenses? Is it one offense for the rifle with all the stuff on it? Or is it a point system where you're violated for the rifle, for the parts, for all of that?
That will not be a decision for the Illinois State Police. That will be a decision for the state's attorneys throughout the state of Illinois.
Last question. This is a question. The Department of State Police had 9 months to produce rules that would clarify poorly or undefined terms and describe how this registry would be implemented. You chose to do so on an emergency basis at the 11th hour, rather than the normal, orderly notice and public comment process. That process requires, I believe, 2 45-day comment periods, which, if you had published these rules in May, after 5 months after the act had passed would have been sufficient. So here we are with emergency rules that will be in effect for 150 days, well past the closing of the registration window. The rules you published largely restate the act without clarifying much of anything. Why did the department choose to enact these rules on an emergency basis at the last possible moment?
The Illinois State Police worked with. The Illinois State Police worked with the Attorney General's Office, the Illinois Department of Natural Resources, and JPAR staff to draft these rules and publish them as quickly as possible.
That's all I have. Thank you.
Thank you very much. Sir, if you would submit your questions to us, it will help to answer all of your questions. Thank you very much. We would invite Mr. Darren Bailey to speak.
First of all, I want to thank you very much for offering this. I want to thank you. This is how a constitutional republic is upheld. Thank you for showing up. I'm sorry that I have utmost respect for the Illinois State Police, and I am so sorry for this tough situation that you are in. I am curious of one thing, probably the only question I have. This is home territory to Illinois State Police Director Brandon Kelly. Is there a reason why he is not here today to face his friends and neighbors?
Director Kelly is otherwise occupied within the state.
Okay, thank you.
Thank you.
Well, I'm here to confront a dire threat that has been unleashed upon law-abiding citizens across Illinois and all over the United States of America. Our Second Amendment rights are under attack, but they are not up for negotiation. To those who believe that we will quietly comply with the gun registry, I have one clear message. You couldn't be more wrong. You can tell our governor, who is comfortably residing in his gated mansion with private security, that if he wants our firearms, he is going to have to pry them from my cold, dead hands. America, where we have fought for our freedoms with unwavering resolve throughout history, we will not bow down. We will not cower in fear. We will defend our liberties and our families from any threat, even if that threat emanates from our own government. But let's get real here. How do you plan to enforce this registry? What's the governor's plan when millions of us choose not to comply? Those are the answers that everyone's after. Are you prepared to lock up over 2 million law-abiding gun owners? Is this why the governor is willing to release actual criminals on our streets, to make room for citizens who simply want to live honest lives founded on hard work, faith, and the cherished freedom to protect themselves and their loved ones? We demand transparency, and we demand respect for our constitutional rights. The road ahead must be one of dialogue and understanding, not one of trampling on the very essence of what makes this nation great. Our founding fathers understood the importance of an armed citizenry as a safeguard against tyranny. We will uphold that legacy with
Next, we would invite Mr. Perry Elder to speak. Are you Mr. Elder?
Yes, I am.
Okay. Mr. Patrick Ferrari. Mr. Patrick Ferrari. And Mr. Hunter Mance. That concludes the Illinois State Police. Appreciate your remarks. If you have comments, we are in the first 45-day comment period of our proposed rules, and you can find the email address to submit comments on our state police website. Yes, sir.
I was on my phone while this was going on. I was having a hard time finding these frequently asked questions on the ISD website.
We can answer.
Yeah.
So if you go to the department website, there should be a blue banner that will pop up right as soon as you log on. If you click that, it will take you to the frequently asked questions that we update as frequently as we can, as well as the tutorial video, any other kind of guide that we have. All of our information is there to try to help you out.
So there's a